Tantor Audio, a division of Recorded Books, presents You Can't Always Say What You Want, The Paradox of Free Speech, by Dennis Barron, narrated by Tom Perkins. Foreword. Free speech is guaranteed by law in the United States, yet there are always exceptions. You may have the freedom to think as you will and to speak as you think, but there are always some things that you want to say but can't. We revel in our free speech. We taunt anyone who tries to shut us up with, "It's a free country, I can say whatever I want." Yet it's never really free speech. It's more like free speech, but. This is a book about our freedom of speech and the legal buts that complicate it. Laws protect or limit the words we use, or at least they try to do so, because statutes that protect free speech often generate attempts to limit that freedom, and laws that limit what we say prompt us to get around those limits. Whether it's a broad law establishing an official language, a narrower one forbidding threats or obscene speech, or a statute that defines a single word, like tomato or marriage, breaking language laws has consequences. Penalties may range from a slap on the wrist to serious fines and long jail terms. The prominent American socialist and frequent presidential candidate Eugene Debs was sentenced to 10 years in prison for protesting American participation in the First World War. Debs knew that the 1918 Sedition Act criminalized speaking against the war, yet he exercised his right to say what he thought and went to jail for his beliefs. Attempts to regulate language in the United States go back to its founding. After the United States won its independence from England, Noah Webster proposed that the new nation drop English and adopt what he called federal language, though he later changed the name to American English. Federal language yoked to common Enlightenment notions that language was national and that it was perfectible. Webster set out to make American English not just independent, but also better than the original, an upgrade to English 2.0. But some of the improvements Webster championed in the school books and dictionaries that he published were quirky. He spelled words to better reflect their pronunciation, or rather, his pronunciation. Webster was from New England, and so in his dictionary, deaf became deef, because that is how he and his neighbors said the word. Webster also rewrote bridegroom as bridegoom, to signal the word's derivation from Old English guma, a word meaning, variously, adult male, boy, or servant. Webster's speller was a hit, and some of his spellings became standard in the United States, like axe, plow, honor, center, and gray. But many of the improvements he put in his dictionary, like deef and bridegroom, proved too eccentric for most people. Although New York's Philological Society promoted federal language in a procession celebrating the Constitution in Philadelphia in July 1788, no doubt because Webster was a founder and mainstay of the group, Congress never adopted Webster's Federal English or made his American Spelling Book the national textbook. Nor has the United States ever designated English as its official language. Yet federal, state, and local governments repeatedly supported the idea of official English, and they frequently passed laws both defending and forbidding what Americans can say or write. Manipulating language is a way of manipulating people, and it's not just the law that shapes our words. Parents routinely correct children's speech, pushing them toward preferred forms, even punishing them for swearing or saying ain't. The concept of a swear box or swear jar, a container into which one puts a coin to atone for each instance of swearing, originates in the late 19th century in England. It is not unknown in American families today, though, given the amount of swearing both in private and in public, its effectiveness has always been limited. Friends police one another's words to force consensus or affirm a group identity, and employers may compel workers to follow prepared scripts in order to protect the brand and increase profits. Or they may silence employees to protect trade secrets and discourage complaints on social media. Failing to follow the company's language rules could lead to reprimands, fines, and even unemployment. Teachers may mold language as well, pressuring students to model standard grammar, accents, and vocabulary, and grading them down when they failed to do so. Webster, a failed lawyer, tried his hand at teaching, which led him to his career as a prescriber of correct English. Teachers in the mold of Webster argue that using standard English will lead to social and economic success, though, as linguists point out, there is no single agreed-upon language standard. Plus, the supposed standards are not innate features of language, not more logical, more effective, or more beautiful than any other variety of speech. Nor does mastering them guarantee success. The standards are merely the forms presumed to be in use by elite groups of speakers and writers, a presumption not always backed up by evidence. The social control of language is a vast topic, best left for other volumes. You Can't Always Say What You Want focuses instead on the legal control of language. Webster was not alone in holding contradictory, even paradoxical views of language. On the one hand, he argued that the words Americans use create a national identity. On the other, he insisted that American English must be perfected, modified, and policed in order to bring that much-desired national identity into existence. As we'll discuss in the following, the connection between language and nation is at best nebulous. Even before the United States gained independence, Americans knew that their English was diverging from the British variety, and it was clear to them that their own English varied from New England to the southern states. The British generally frowned on words perceived to be American. Many still do so today. So did some Americans, though others chose to celebrate the American language, even to enshrine it in the law. Controlling what we say and write often becomes a way to protect the national identity, the brand. At least that is what supporters of official language laws contend. And laws forbidding certain kinds of speech, like swearing, threatening, or lying, enforce ideas about class, race, gender, and appropriate behavior, even though the speakers of a language may ignore or actively rebel against these norms. Despite the laws and the cajoling of parents and teachers, of employers and friends, people continue to swear and threaten one another. They still say ain't. They violate language taboos. And in the words of the fictional Dr. Gregory House, everybody lies. You Can't Always Say What You Want focuses on the history of several key free speech issues: political speech, obscenity, threats, official language, and compelled speech, in order to provide some background to the current threats to free speech in the United States, with references, where applicable, to freedom of expression in Britain and in the European Union, EU. Although liberal democracies like these have generally expanded speech rights over the years, that is no reason to be complacent. Some laws do broaden speech protections, but others continue to chip away at these hard-won freedoms. As we look at the laws that protect or limit speech, we'll consider as well how courts interpret statutes, particularly those laws that deal with language use. Originalism, a method popular in American legal circles today, seeks to determine what reasonable people understood the Constitution and the early laws of the United States to mean at the time they were enacted. But as we'll see, that original meaning may be difficult or impossible to recover, and so other legal scholars prefer to read a law both practically and flexibly, understanding the meaning of older laws in light of present conditions in order to achieve an outcome that promotes the common good. Although the scope of this book is broad, there are aspects of language law that I have not had room to address. These include defamation, a topic too varied and complex to be treated here, yet one with important connections to the freedom of speech and of the press. Case in point, former vice presidential candidate Sarah Palin sued the New York Times for defamation, claiming that the Times recklessly disregarded the truth when it printed a 2017 editorial mistakenly connecting her political rhetoric with a 2011 mass shooting in Arizona, even though the newspaper quickly corrected its error. But both the judge and the jury rejected her argument that the Times had acted with malice, finding instead that the newspaper had made an honest mistake which it quickly corrected. She failed to convince the courts to reverse the precedent set in the 1964 Supreme Court decision in New York Times v. Sullivan that public figures must prove in a defamation suit that damaging misinformation about them wasn't simply an honest mistake, but was instead the result of actual malice on the part of the writer. Other areas I do not address include blasphemy, not a current problem in the West, but one which remains an issue, sometimes a life-or-death issue in many parts of the world, and commercial speech, including the laws of intellectual property and of trademark and copyright. I do not cover the expanding field of forensic linguistics either, with topics as varied as the linguistic structure of police and courtroom interrogation, the impact of the common mistranslation and mistranscription of witness testimony or patient interviews, document verification and author identification, and the identification or exoneration of suspects or defendants through linguistic analysis of their speech or writing. In the interests of brevity, I must leave a deeper exploration of these important aspects of language law to other books and other scholars. Chapter 1. Free Speech, but The defense in former President Donald Trump's second impeachment relied in part on the assertion that his speech at a rally on January 6, 2021, was protected by the First Amendment. Trump spoke for more than an hour to a crowd of thousands outside the White House at a rally that he himself had been promoting for months, one that he had promised would be wild. Trump repeated the lie that the 2020 presidential election had been stolen from him. He used the word fight 20 separate times, and he promised his supporters that he would march with them down Pennsylvania Avenue to the Capitol to stop the steal. When he finished speaking, Trump did not join the 10,000 who marched to the Capitol, and while the world watched in horror, hundreds of them broke into the Capitol building where they attacked police, ransacked offices, and roamed the hallways looking for lawmakers to punish. They erected a makeshift gallows on the Capitol grounds. Some rioters shouted, "Hang Mike Pence," as they marched through the building, a response to Trump's insistence that the vice president had been too weak to stop Congress from counting the Electoral College ballots that would confirm Joe Biden as president. The events of January 6th have been called a riot, an insurrection, an act of domestic terrorism, or by some of Trump's more ardent supporters keen to erase the memory, a peaceful demonstration that got a little out of hand. In the weeks and months that followed, more than 725 were charged with offenses ranging from trespass and resisting arrest to assault with a deadly weapon to seditious conspiracy, a crime which carries a maximum penalty of 20 years in prison. The Capitol invasion left 7 dead, including 3 police officers, 140 officers injured, some seriously, and $1.5 million in property damage. And it left this question: did Donald Trump incite the riot that day, or were his words protected by the Constitution? It has become common in the past few years for the American conservatives to reject any criticism of their words by invoking their freedom of speech, and they're quick to label any criticism of their positions cancel culture, an attempt to deprive them of their First Amendment speech protections. The far right similarly rejects firearms regulations as violations of their Second Amendment right to keep and bear arms, as long as the guns in question belong to conservatives and not progressives. They defended Trump's words as peaceful, and they rejected the notion that the rioters were armed or even rioting. Although police confiscated a significant number of guns and other weapons from the invaders of the Capitol, and millions watched the riot unfold on TV, Senator Ron Johnson of Wisconsin told a Milwaukee radio interviewer, "This didn't seem like an armed insurrection to me." Representative Andrew S. Clyde of Georgia went further, calling the Capitol riot a normal tourist visit, normalizing the events still further by referring to them as constitutionally protected free speech. In February 2022, the Republican National Committee declared the January 6 insurrectionists ordinary citizens engaged in legitimate political discourse. District of Columbia law makes clear that the rioters' weapons did not have Second Amendment protection. But were Trump's words constitutionally protected speech? The relevant part of the First Amendment states, Congress shall make no law abridging the freedom of speech. It turns out that no in the Constitution doesn't always mean no. As we'll hear in the chapters that follow, fighting words and threats have never been protected speech. And for much of American history, political speech wasn't guaranteed protection either. Criminal or seditious conspiracy are not protected. Neither is incitement to riot. The unanswered question hanging over the events of January 6th is this: did Trump's words incite the violent acts that followed? And if they did, can he be held accountable? Freedom of speech is never absolute. Justice Oliver Wendell Holmes said in Schenck v. United States, 1919, the Supreme Court's first free speech decision, "The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic." We'll examine Schenck in detail in Chapter 3. But in affirming the convictions of two First World War draft protesters, the Schenck court ruled that speech posing a clear and present danger to the nation can't hide behind the First Amendment. In Trump's second impeachment, the former president's lawyers invoked two different First Amendment decisions: Watts v. United States, 1969, and Brandenburg v. Ohio, 1969. We'll examine both of these cases in detail later on as well, but neither case furnishes a good defense for the former president. Robert Watts, referring to then-President Lyndon Johnson, said, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ." Watts wasn't about to shoot anyone. People laughed as he aimed an imaginary rifle at an imaginary Johnson. The U.S. Supreme Court found that Watts's words, though hyperbolic and perhaps ill-chosen, posed no danger to the president. They did not cause a riot. They did not encourage anyone to harm the president or anyone else. Instead, the court declared that what Watts said was protected political speech, a peaceful protest against what he considered an unjust war. Brandenburg also fails to protect Trump's words. Ku Klux Klan member Clarence Brandenburg invited a local TV reporter to film a rally of a dozen men wearing sheets in a remote Ohio field where they burned a cross and made threats against Jews and blacks. But the Supreme Court reversed Brandenburg's conviction because his words, though hateful, were spoken to a small group in a remote location where they could have no broader impact. They were not likely to produce what the court termed imminent lawless action. The words of Watts and Brandenburg were protected because their tiny audiences did not and could not act on what the speakers said. In contrast, Trump spoke to a crowd of thousands primed for action. Many of the listeners, by their own testimony, were waiting for his command to attack an unprotected Capitol. Trump urged them to fight and told them to march. Although his lawyers insisted that Trump meant fight in a figurative sense, many in the crowd literally marched and they literally fought. It was textbook imminent lawless action. Trump's lawyers insisted that his speech was hyperbolic. He didn't mean for anyone to break the law. But Senate Minority Leader Mitch McConnell, a longtime Trump supporter, disagreed. McConnell, who had been trapped inside the Capitol by the mob, acknowledged that Trump's words were practically and morally responsible for the Capitol riot. We'll consider a speaker's intent in more detail when we discuss threatening speech in Chapter 5. But for now there is lots of evidence suggesting Trump's state of mind. There is his long record of violent rhetoric in his private conversations, his public speeches, and his Twitter posts. After January 6th, the social media platform blocked him. He never seemed to care when his words caused chaos or damage to individuals, to financial markets, to America's trading partners or the nation's allies around the world, even to Americans trying to cope with the COVID-19 pandemic. At various times he told his audiences to rough up protesters and lock up his opponents. He suggested drinking bleach or trying unproven drugs to fight the coronavirus. Some people followed those instructions. And for months he had promulgated the big lie, urging his followers to reclaim an election he insisted had been stolen from him. All of this led up to Trump's rally in Washington on January 6 to stop the steal and to the riot that followed. In light of the Supreme Court's rejection, in Terminiello v. Chicago, 1948, of the heckler's veto, banning speech because of fears that the audience might respond violently, it would appear that Trump's speech that day could not have been prevented by authorities who feared that the crowd would overreact. But even if the president's words, and those of his then-attorney Rudy Giuliani and other speakers that day, were constitutionally protected, the police should have been prepared for the lawlessness that followed. Trump himself did not engage in violence, even if he egged others on. After promising rallygoers that he would accompany them to the Capitol, he returned to the White House. There, his reported actions further revealed his state of mind. He was said to be delighted watching the Capitol riot on TV. He did nothing to rein in his followers despite pleas from advisers that he intervene. He ignored warnings of danger and urgent requests for help from political allies like Senator Tommy Tuberville and House Minority Leader Kevin McCarthy, who, like Mitch McConnell and Vice President Pence, were trapped in the Capitol. He even encouraged the mob to go after Pence. Hours later, as police began to get things under control, Trump posted a video asking rioters to go home. But even then he repeated his charges of a stolen election and told the rioters that he loved them. In the days that followed, rioters defended their actions by saying that they were only following Trump's orders. All this suggests his intent. As the Supreme Court acknowledged in Watts, political speech can be raw, rowdy, belligerent, in your face. As long as it remains speech, it enjoys First Amendment protection. But once speech is accompanied by lawless action, it is no longer protected. And in any case, freedom to speak doesn't protect speakers from the consequences of their speech. When Trump's words were directly followed by rampage, unlawful entry, property damage, injury, and death, there seems no way to give those words First Amendment cover. And the question remains for those who still insist Trump was simply exercising his right to free speech like any other American. Shouldn't a president know better? The First Amendment guarantees the right to speak. It also guarantees the right of the people peaceably to assemble to petition the government to redress their grievances. But the right to speak and protest doesn't mean you can stop the members of Congress from carrying out their constitutionally mandated duty to count the Electoral College ballots on January 6th. Similarly, the right to keep and bear arms doesn't mean you can violate local gun laws, and it certainly doesn't mean you can use weapons to assault or threaten other people. It is a free country to be sure, but experience and the law show that we can't always say what we want. That doesn't make free speech a myth, but it shows that the freedom to speak is never absolute. As the events of January 6th reveal, wrapping yourself in the First Amendment doesn't make what you said protected speech. And wrapping yourself in the Second Amendment doesn't mean you can strap on your guns to storm the Capitol. Nor does it mean that you can use your right to speak and bear arms in order to silence someone else. Two forces threaten free speech in America: people who assert their free speech rights in order to suppress the speech of others, and people who exercise their right to bear arms to silence whoever they do not like. Both forces invoke the Constitution to drown out the voices of the poor and the powerless, the very minorities whose rights the Constitution would normally guarantee. One claims that the First Amendment guarantees them a speech platform which they can use to silence their critics. The other insists that the Second Amendment guarantees their right to bring a gun to the state legislature or to a political demonstration, or even to a voting booth to silence anyone with whom they disagree. There is a third force eroding free speech as well, one I will look at briefly in my concluding chapter: the increasing erosion of our privacy that accompanies recent advances in digital technologies. These threats do not make free speech an illusion, but they do remind us that the right to speak, a right embedded in the fabric of democracy, must always be defended. And they reveal a gap between popular definitions of free speech and the legal understanding of the right to speak. Freedom of speech is never absolute. The First Amendment reads in part, "Congress shall make no law abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." The meaning of no law seems plain enough. You do not need a dictionary to tell you that no means no. But in practice, the First Amendment means Congress may make some laws abridging the freedom of speech. In other words, even though it is a free country, you can't always say what you want. There are laws against all sorts of speech. Massachusetts, Michigan, Oklahoma, and Rhode Island are just some of the states with no public swearing laws currently on the books. They are not quaint holdovers from a more prudish time. The week before I drafted this paragraph, a Georgia woman was jailed for cursing in an elementary school within earshot of the children. Federal law makes it illegal to threaten someone on social media, and it used to be against the law in the United States to criticize the president, to protest a war, even to sing a song in a language other than English. The First Amendment also protects Americans from compelled speech. You can't be forced to say something against your will, like the Pledge of Allegiance. But just as the government may prohibit some speech, it may also compel certain kinds of speech. If you want a government job, you can be forced to sign a loyalty oath. The Constitution requires the president to take the oath of office before assuming their duties, and police must read an arrested person their rights. The government may compel product labels and warnings. And here's an irony. The Fifth Amendment protects the right to remain silent, but in 2013 the Supreme Court ruled that a prisoner must speak in order to invoke that right to silence. In fact, all sorts of laws, rules, and regulations tell us what we can and cannot say or write, and violating them may be costly. Criticizing the president in 1798 or writing anything false, scandalous, or malicious about the government could mean jail time and a $2,000 fine. That's about $40,000 or 30,000 pounds today. Protesting the war in 1918 or saying anything disloyal, profane, scurrilous, or abusive about the U.S. government or its policies could get you 20 years and $10,000, about $160,000 or 117,500 pounds now. Teach a German song in 1920 in a Nebraska private school? You'd be fined up to $100, $1,200 or 880 pounds today, with up to 30 days in the county lockup. Don't even think about traveling to New York from the Italian Riviera in 1929 with a copy of Lady Chatterley's Lover stashed in your luggage. You would be relieved of the racy novel at the pier, not by a pickpocket looking for a thrill, but by a customs agent. Broadcast a comedy routine in 1973 about 7 dirty words you can't say on the air, and the FCC might fine the offending radio station or, worse yet, revoke its license. Wear a jacket with an obscenity about the draft written on it inside the Los Angeles County Courthouse in 1968, as Paul Robert Cohen did, and you will get 60 days for disturbing the peace. The U.S. Supreme Court later reversed Cohen's conviction because his anti-war message was protected political speech. But don't even think of wearing clothing with anything political on it when you visit the Supreme Court today, or you'll be fined, imprisoned for up to 60 days, or both. Although this list of don'ts is hardly exhaustive, the First Amendment does guarantee free speech, and when it comes to political speech, that guarantee is particularly robust. Today you can freely criticize a president or a war, or voice your opinion on any matter of public concern. It is legal to sing a song in Spanish or Farsi or Navajo. It is legal to swear on cable TV or on the Internet. And Lady Chatterley's Lover is not only legal, it's got 100,000 ratings, averaging 3.5 stars on Goodreads. What the First Amendment does not protect is your right to speak on social media. The First Amendment only limits government attempts to regulate speech. The Constitution doesn't typically concern itself with private speech controls, the kind imposed online, as well as by employers, schools, or social and religious groups. So Donald Trump was wrong to complain in 2020 that social media was violating his free speech rights and trying to cancel him by flagging some of his more misleading tweets, or when those platforms banned him for the lies he posted on January 6th. Facebook and Twitter are free to regulate what users upload to their platforms. When Trump's supporters proclaimed on Fox News that they were being silenced, it was clear they still had a platform on America's most popular news network. These speakers crying cancel culture, who've already amassed large audiences, are essentially trying to cancel their critics, who typically command much smaller audiences. The second threat to our free speech rights is another constitutional amendment. In 2008, the U.S. Supreme Court ruled that the Second Amendment protects an individual's right to own a gun.
Sample complete. Ready to continue?